Hi, it's Wendy Hernandez. In today's video, I'm going to talk to you a little bit about cases where it's he said versus she said, or it could even be she said versus she said, or he said versus he said. In these types of cases are cases where it really boils down to what one person is saying versus what the other person is saying, one person's word versus the other person's word, and who the trier of fact, which could be a judge or a jury, is going to believe. So in these cases, credibility is at issue. And in every family law case or every case that goes to trial, the credibility of the witnesses is at issue. So what credibility means is how believable is each witness. And there are a lot of things that the judge or the trier of fact can look at in deciding whether or not to believe a witness. Just a list of a few of those things that the judge or the jury will look at are the person's manner while testifying, meaning are they acting nervous? Are they pausing a lot before answering certain questions? Do they seem antsy? Do they start crying? Are they sweating? All of these things can be considered in deciding whether or not to believe a witness. Some other things that a judge might look at are the person's nonverbal communication, whether or not they get hostile when the other attorney or party is cross-examining them, their ability to recall important events or details or dates, and how specific their testimony is when it relates to important events. And there's more things that a judge or a jury can look at in deciding whether or not to believe a witness. That's just a list of a few of the things. So keep this in mind as you're getting prepared to testify in your family law case, and also as you're getting your witnesses prepared to testify in your family law case. In any case, it's really important to practice your testimony and the testimony of your witnesses before you set foot in the courtroom. I always set my clients down and we go through a role-playing exercise, sometimes twice, 3 times, and even 4 times before we go into the courtroom, especially if my client is having some anxiety about testifying, and most of them are, because it's just not a natural situation to go into court and testify about something as personal as your case, your kids, your money, and property and debts and things like that. So it really does help to practice. So if you're able, I would encourage you prior to going into the courtroom to get your questions or the areas that you want to focus on, and sit down and have a family member or a friend ask those things to you and practice and refine your answers. Also, do the same with the witnesses that are going to testify on your behalf. Prepare your questions ahead of the trial, and sit with them and let them know what is going to be coming, what you're going to be asking, what you're going to be looking for when you're asking them about an exhibit, for example. And prepare them as well to be cross-examined by the other attorney. This is a big mistake that people make when preparing for trials. They may get themselves ready and they may get their witnesses ready to testify on direct examination, but then they don't prepare those witnesses or themselves to be cross-examined by the other side or the other attorney. And cross-examination is it can be a very stressful thing. It can be a heated thing. And just remember, during cross, just keep your cool. Tell your witnesses to keep your cool. But above all, always be straightforward and forthcoming with the court. In some states, in some jurisdictions, the court can actually ask the witnesses on the stand a question, or the juries can write notes to the witness on the stand and ask questions. So don't hide anything, because also testifying and not giving full information, if the judge or the other party reveals that you haven't given full information, really could come back to bite you. And I just want to give you a brief example of that. I got a court decision yesterday from a trial that I had a few weeks ago with a client of mine. And one of the things at issue were the parties' incomes. And in Arizona, there are some situations where employment bonuses can be counted as income. And my client and I were wanting to count the husband's employment bonuses as income, and they were significant bonuses. We're talking like $28,000 and $26,000. So I'm looking at my phone and I'm looking at the judge's ruling. But after we had presented the evidence, the judge had asked the husband, out of the last 5 years, how many years had he received bonuses? And his answer to her was he had received bonuses in 2 of 5 years. What the husband did not tell the judge, however, is that he had been working for his current company, and that is Microsoft, for only 3 years. So for 2 out of the 3 years he had been working for Microsoft, he'd actually received bonuses. So in the judge's decision, she referred to that failure to reveal information, and this is what she said. Father works for Microsoft. He received bonuses 2 of the last 3 years he has worked there. In 2015, he received $28,850, and in 2014, he received $26,000 for an average of $27,425. When asked by the court how often he received bonuses, Father failed to inform the court he had only worked there 3 years, leaving the impression he did not receive bonuses frequently. Then, pursuant to Arizona law, bonuses may be included in gross income. The court finds it reasonable to include the average of Father's last 2 years of bonuses in the salary. So this issue, I think, was one that could have gone either way. But because Father did not give the judge all of the information, that really ruined his credibility with the judge, and she ruled against him on that particular issue, which benefited my client over the long term because she's getting more child support per month because of it. So I just give you that little story to illustrate that even if the judge is asking you a question and you don't want to give the answer because you think it's going to hurt your case, give the answer anyway, because it's going to hurt your case more over the long term if the judge finds out you're lying. The judge may never trust you again if you go back to that judge in the future, and it could hurt you in the judge's ruling. So those are my thoughts on credibility. Credibility is always an issue, so practice your testimony, practice the witness testimony with the witnesses that you're going to present at court, and just remember to always be upfront with the judge or with the jury. So I hope this little video on credibility helps you, and remember to subscribe to us on our YouTube channel. Also, if you want more information about the Command the Courtroom offerings, go to commandthecourtroom.com. I'm Wendy Hernandez. I'm on your side when it matters most, so go out there and get them in your case.